Hi, this is Paul Hitchcock with the Asset Protection Estate Planning firm Barth Calderon. Thanks for listening. I'm here with my colleague David Calderon. Hi, David.
Hey, Paul. How you doing?
Good. And this is a really important issue. David brought it. We were talking about this yesterday. I guess there was an article that came out about the independent contractor versus the employee scenario, and you mentioned it kind of was, that Uber and Lyft were in this discussion. So what's going on with this thing?
Well, the California Supreme Court just came down with a decision that's going to dramatically impact California businesses' ability to hire people and bring them on as independent contractors as opposed to employees.
Okay, is this, give me an example of what this means. Like you mentioned Uber, Lyft, and maybe there's other companies. What exactly does this mean for bringing somebody on?
Well, it really is a case that I think is going to have major implications for what's called the gig economy, for people that work for Uber and Lyft as drivers, but also it's going to have a ripple effect that's going to hurt any company that really depends on independent contractors to kind of populate its workforce and to get its work done. It used to be that the independent contractor test in California really depended on how much control a company would have over the people that they've hired over independent contractors. And now what the California Supreme Court has said is that it's not only a factor of control, but if you're hiring people that are involved in the same type of business that you're in and classifying them as independent contractors, that could be considered a misclassification.
Oh, okay. So you and I were talking offline. I think an example of that you were talking about is we're a law firm here. So if you hired somebody, a plumber or an electrician, that's an independent contractor, obviously. But if you hire somebody here who's maybe doing some part-time legal work, no longer an independent contractor, or maybe. Is that an analogy?
Yeah, that's a good analogy, and that's actually the analogy the court used. The court said if you have a leak in your house, you call a plumber, the plumber comes and fixes the leak, or if you're a business, you have a leak in your pipes, in your building, and you call a plumber, and the plumber comes out and fixes it. That would be considered an independent contractor type of scenario, or an electrician that may fix a light bulb.
Because it has nothing to do with your core business.
Correct.
Yeah.
But what they said, for example, if you are a textile company and you manufacture cloth, and you hire somebody as an independent contractor to make dresses using your cloth, that person may now be considered an employee as opposed to an independent contractor, for example. And right now, the decision that the Supreme Court came up with affects only wage and hour laws and wage and hour orders in the state of California. But it's likely just the beginning of what is probably going to be either gradual or it could possibly be a very quick erosion of laws involving independent contractors in California.
So what would business owners, what do they do about this? I mean, do they just kind of sit and wait for what's going to happen, or how can you be proactive, or what do they need to watch out for?
Well, I think what businesses need to do is possibly to call their attorney if they have one, to talk to them about what they should do in response to this new case. As I said, I just think it's the beginning of many other cases to come that are going to opine on the independent contractor versus employee relationship. It's been estimated by the California Chamber of Commerce, for example, that the state loses up to $7 billion a year on payroll taxes due to a quote-unquote misclassification of independent contractors versus employees.
Oh, interesting.
There's also issues, for example, like with Uber and Lyft, where their employees commit torts on the job. There's been an uptick in sexual assaults involving Uber drivers and cars and Lyft drivers, and whether or not Uber and Lyft should be responsible for things like that.
Right.
So, while right now the California Supreme Court said it only applies to wage and hour claims like overtime, meal periods, rest breaks, in the future I think the California Supreme Court is going to expand that to cover payroll taxes, to cover the situation where supposedly independent contractors commit torts, things along those lines. So to me it's just kind of the beginning of a wave to classify more workers as employees, collect more tax dollars from employers, and also make employers more liable for the actions of the people that they actually employ.
It's a big deal. Well, so of course we're all over this issue here at our firm, being an asset protection firm, and so we're really reaching out to folks. This is one of the ways we're doing it, to deliver this new message. And If you're watching this, there's a great link here, or maybe it's down here, depending on where you're watching it, on an article that addresses some more of this detail. And if you have any questions, feel free to comment, reach out to us, get you connected to David for some input. But thanks for listening, David. Thanks for sharing.
You bet. Thanks,
All right,
Paul.
yeah.
You got it. Thank you.
See ya.